audio system in these strange circumstances, which is why I moved out of the plexiglass after yesterday. And I don't know whether my colleagues will choose to do that on the fly or not. But anyway, we hope you'll be able to hear us, and we hope we'll be able to hear you. We have our usual traffic lights here. The red light is your cutthroat signal. Please conclude your argument unless you're answering a question of the court. And we also appreciate record citations because although we have read the briefs and record excerpts, we may not have read the entire file before we get here. First case of this afternoon is 20-60086, Dockery versus Cain, and we'll hear from Mr. Salk.
Good afternoon, Your Honors, and may it please the Court. Benjamin Salk for the plaintiffs in this case on behalf of the class of all men incarcerated at the East Mississippi Correctional Facility.
Can you hear? Good. I'm glad you can.
Shall I speak up a bit, or?
I don't know if that'll help, but see what you can do.
Okay.
Thanks.
Your Honors, this is a very long-running case with an expansive record, but the issue before this Court is simple and narrow. Put plainly, the district court simply did not apply the proper legal standards to the record, and it did not decide the legal questions which it was required to decide.
So, Mr. Salk, just picking up on what you just said, that this case, in your view, presents a narrow legal question, do I take that to mean that you are not contesting any fact-finding made by the district court in its opinion for clear error?
Your Honor, we believe that the issues before this court should be reviewed de novo because they are errors of law.
So I've read the district court opinion a few times. It's 50-something pages long. I read a number of fact findings. Do I understand that you are not challenging any of those fact findings for clear error?
That is correct, Your Honor. However, the court's fact findings were informed by an erroneous view of the controlling relevant law, and therefore they should be remanded.
So, for example, when the district court at page 19 and 20 of its opinion made findings with respect to the expanded medical staff, and also with respect to sick call requests being assessed within 24 hours, et cetera, you're not saying to us that those are clearly erroneous fact findings?
Although we dispute the veracity of those fact findings, that is not the issue before this court, Your Honor.
So you're not making an argument that those are clearly erroneous fact findings?
That is correct. Yes. Your Honor, however, the argument that we are making is that the court's fact findings throughout its opinion were the result of an erroneous view of the relevant legal standards, and therefore they were both inadequate to address the proper legal questions that it was required to address and not analyzed properly under the controlling law. So in other words, although we don't contest those specific findings, we do note that the court did not draw findings that were sufficient to answer the relevant legal questions. And what I mean by that is, under Wilson v. Siler and under many cases of this circuit, the relevant approach for an Eighth Amendment prison conditions case is necessarily context specific. The court must look at all of the circumstances as they affect the people at this particular prison and decide whether those circumstances, taken together, including any mutually enforcing effects, expose people to a substantial risk of serious harm. That's the relevant question, and the court never answered that question with respect to the three claims that we've raised on appeal here, Your Honors. So
if that means maybe the court, in your view, should have done more, and if it had looked in the totality, it would have found the serious harm, the objective part of the inquiry. How would that alter the court's findings that the prison officials were not deliberately indifferent because they took a number of affirmative steps to address the medical issues, to address the concerns about inadequate staffing, et cetera?
Well, Your Honor, under Farmer v. Brennan, the court must decide whether there's a deliberate indifference to a substantial risk of harm. If the court doesn't properly define what that substantial risk of harm is, then it can't decide whether the officials were deliberately indifferent to it. So, for example, the court in this case separated out a number of conditions and looked at them serially and found that they didn't violate the Constitution per se. They didn't violate some sort of objective benchmark. For example, just by way of one example, on the solitary confinement claim, the court found that the length of time people were held in solitary confinement didn't violate the Constitution because courts have found longer periods of time to be constitutional. Without applying that, without considering the context in which that occurs in this case, the court could not appropriately determine what the substantial risk of harm was to the plaintiffs in this particular prison. So when the court found that there was no deliberate indifference in this case, Your Honor, it did that with respect to certain conditions that were not the appropriate. It didn't first find the objective requirement as it needed to do.
But it seemed that essentially it did. I mean, it said it very much suggests that there were violations in the past, that there were conditions that rose to the level of serious harm, but then says, in the court's view, it was fixed because they hired a new contractor, put in procedures if there's no, 3 straight missed medications, et cetera.
That's correct, Your Honor. It cited a number of changes that had been made, which, in the court's view, reflected a lack of deliberate indifference to the harm. However, those changes didn't actually address, nor were they targeted to address, the actual harm that is constitutionally relevant here, which is the fact that the conditions in totality, as they affect people, expose them to a substantial risk of harm.
So just following up on what Judge Costa just said, the district court explicitly said the prison that was there at the beginning of the lawsuit was not the one that was there at the end. Would you agree that taking into account developments and improvements to the prison during the course of this lengthy litigation is consistent with what Farmer versus Brennan says a district court ought to do?
Absolutely. That is part of what a district court should do and must do. However, what the court should also do, and which I think is consistent with Farmer and consistent with what this court recently held in Valentine, is that the court should consider the entirety of the factual record from filing until judgment. And so, although there may have been changes which the court credited with remedying these problems, and again, this is in the alternative, assuming there were no Eighth Amendment violations at the time of judgment. We maintain that there were, but even if there were not, those steps, those remedial steps, should be viewed in the context of the entirety of the factual record. And so in that context, Your Honor, it's proper to consider those things, but it doesn't necessarily defeat liability, nor does it show that an injunction should not issue.
Okay, I read Farmer as specifically saying that's exactly what a district court ought to consider, the ongoing developments, the ongoing improvements, in order to consider whether an injunction should be issued.
It's very much a relevant consideration, I agree. It is not determinative, however. And when those efforts, when remedial efforts are not permanent, and when there is, well, really under any circumstance, the court is required to look at whether there is a risk of recurrence.
Well, so to that point, I mean, here you have a district court very forthrightly saying there was corruption in the MDOC. Two officials are now in jail themselves, and so as a result, the prison made changes to hired different people to run various aspects of the prison, and then the court documented what the improvements were as a result. So what can you point to in the record that suggests that there is a danger or likelihood of recurrence of the conditions that were there before?
Well, Your Honor, first of all, the specific factors that the court pointed to had existed during the pendency of this litigation. So the court pointed to, in its post-trial order, it said, its post-trial order in which it ordered further discovery into then existing conditions, the court said explicitly, had the conditions continued to exist as reflected in the complaint and in plaintiff's 2016 expert reports. So using that 2016 moment, putting a pin in that and saying, in the late 2016, the conditions very likely still violated the Constitution. It nonetheless ordered further discovery into conditions that persisted after that. So looking at the 2016 moment and considering the changes it apparently credited with resolving the constitutional issues, it's clear that, first of all, Christopher Epps went to prison in, I believe it was 2014. There was Warden Frank Shaw, who the court credited with having spearheaded some purported changes in policies and practices. He arrived, I believe, in 2015. And Centurion, which was the medical provider that replaced the previous provider whose principal had gone to prison, arrived in 2015 as well, if I'm not mistaken. So the court credited these changes with fixing a constitutional violation that it itself stated existed as of 2 years after those changes took place. That in itself is a very strong indication that there's a risk of recurrence, because these changes did not immediately or directly lead to the changes that the court credited as resolving the constitutional problems.
Counsel, on this legal question of whether you can get an injunction when there's past violations and a risk of future violations but no present violations, I think your best case is Porter from the Fourth Circuit. Tell me if you think there's another one that's better. In that case, the district court granted an injunction in those circumstances, and the Fourth Circuit, in a divided opinion, said that was permissible. Does that mean a district court has to grant an injunction in those circumstances, given the inherently equitable nature of injunctive relief?
Porter does not mean a court must grant an injunction. However, a court must consider whether the risk of recurrence persists. And this court, the district court here, never asked the question. In fact, at oral argument, in closing argument, this legal standard, plaintiffs proposed and stated that the court should consider it, and the court explicitly said that is a statement without a lot of meaning. Risk of recurrence, anything can recur, that's a statement without a whole lot of meaning, I believe is the direct quote. And so it was clear that the court's opinion was shot through with this this application of this misunderstanding of what the relevant legal standard was with respect to risk of recurrence.
So your view is that the district court is required to make a finding that there is, I don't know what standard you think, likely not to be a recurrence of the previous conditions?
Where there is, as here, evidence of a past violation of the Constitution, and where there is reason to believe in the record that it may recur, the court should consider whether there is a cognizable risk of recurrence.
Okay, and do you get that? I mean, Judge Costa mentioned the Porter litigation from the Fourth Circuit. Are you getting, is sort of the source of this principle Farmer itself?
The source of this is it's general equitable principles applying to in the injunctive context more generally, Your Honor. So this court articulated in Shanks v. Dallas in 1985 that an injunction should issue when it's necessary to prevent a cognizable danger of recurrence. And whereas here, the plaintiffs urge the court to undertake that analysis, and the court does not, that is a legal error.
Let me ask you a question. If this were a trade secret case if somebody stole one trade secret in a company that had, let's say, 50 of them, stole one, they caught the fellow, they sued for an injunction. He said, oh my gosh, I'll never do it again. I just had to help out my friend who was struggling, and he whines and cries before the court, and the court finds that he'll never do it again. Can the court issue an injunction?
In that case, Your Honor, I would say no, because I don't think the facts support a finding of there being a cognizable risk of
Well, doesn't your argument come close to saying because things were bad in 2012, 9 years later in 2021, there's a possibility of an injunction?
Well, two things on that, Your Honor. I would say the court must consider that question when asked, and it did not consider that question.
Well, because he didn't find that things were unconstitutionally bad, and he found that the reason that they were bad before had been eliminated.
That's correct, and I think your hypothetical also, Your Honor, is distinguishable because that is not a systemic case involving an institution where policies and practices have not fundamentally changed. So the things that have been pointed to, that the district court pointed to for showing a likelihood of that these were not likely to recur, were changes in personnel, changes in contractors, all of which can be undone at a moment's notice. So it's distinguishable from a one-off situation like you present, Your Honor. And I would just briefly return to the point. As with this injunctive point, the issue with the court's failure to consider all of the facts in deciding whether there is a substantial risk of harm is a matter of, it's a legal error which this court can remedy very easily by directing the district court to simply reevaluate the record, applying the correct legal standard.
Well, the judge in question passed away, so it wouldn't be that easy a matter, but your time is up. You have time for rebuttal.
Thank you, Your Honor.
Mr. Siler, when you're ready.
I am, Your Honor. Thank you. May it please the court. This is such a fact-intensive inquiry for this case that it's hard to understand from my point of view how you can say that you don't have a disagreement with the factual findings of the district court and yet concoct an argument. That's being disrespectful. Make an argument that indicates that the factual findings don't make that much difference.
Well, Mr. Siler, I take the argument from the other side to be the one that's laid out in Justice Scalia's opinion in Wilson versus Sider. Whether that's a legal question or factual question, you can tell me. I don't know. But it's saying that if you have a unconstitutional conditions analysis that says, well, the temperature wasn't all that low, so no unconstitutional condition there, and the fact that they didn't have blankets, that's not that bad, and the analysis fails to combine those two things, then that's an error. Whether it's factual or legal, I don't know. I take it that's their argument. Where I struggle is to see where in the district court's opinion it did something like that. And I don't know if you can respond to my confusion, but that's my confusion.
I think I understand the court's point. And a lot of this is what facts you're looking at and what you're talking about. In this case, the plaintiffs took a shotgun approach to this argument. They shot all these complaints and alleged inadequacies that the prison was doing from their point of view up on the wall to see what would stick. Now, did the court consider a broad range of factual underpinnings to those claims? It did. It considered all kinds of things. When it made a decision that the prison was adequately staffed it did so looking at a broad range of underlying facts to reach that conclusion. And I think what Judge or Justice Scalia was trying to do in Siler was to take the fact that the courts had begun running with this totality of the circumstances argument that didn't really appear in the majority opinion in Siler. It was, those words were never used by Justice Scalia, I'm sorry, by
Well,
he was really good. He was talking about Rhodes
I think
versus
the reason for that observation in Sider was to reject the idea that we have to have an overall conditions analysis.
Well, and he specifically said that.
Yeah, and it was a concession that, well, sure, sometimes certain conditions can be interrelated and can lead to an unconstitutional condition, blankets and temperature being the example I think he used there. But it was to reject the idea that there's an overall conditions analysis. That's how I understand it.
Well, me too. And he said you couldn't do anything as anomalous as throwing all these things up and saying just because you've got 20 different complaints, that even though individually each one of them didn't amount to a deprivation of Eighth Amendment protections, that there's some super Eighth Amendment violation by virtue of the fact you've got all these unrelated claims out there. And I think he was trying to put some brakes on this concept and trying to say, at least if you want to use a lot of different facts or a lot of different claims, they at least need to be related in pointing to a single identifiable issue. And that's my view of what
So on a single identifiable issue, take the protection from harm claim, the district court does go through and says, well, look, they challenge this indirect supervision, but I'm not going to say that that creates a serious condition. And they challenge the staffing, not enough people are showing up for work, they don't have enough people. And I guess the plaintiff's position is it needs to look at those together. Would you concede it didn't say, well, maybe on its own, indirect supervision's fine. A lot of prisons around the country do that. And maybe on its own, I mean, staffing, but looking at it in totality, it's creating this serious danger of rapes and violence and gang control.
And I understand the position that they're talking about, and I understand that I don't believe anywhere in the opinion where he actually does that, but he didn't do this with blinders on. This man sat through almost 6 weeks of trial testimony, and he went to that facility and personally toured it. He understood the totality of what the plaintiffs were claiming and how this all had settled down by the time he was writing this opinion. And in fact, he took it so seriously that he gave the plaintiffs an opportunity, and the defendants as well, to bring their expert witnesses back into that facility post-trial to look at it again and provide supplemental reports just to make certain that what he had seen in that facility, changes that had gone on, to get everybody's views on how all that worked. So I think it's somewhat disingenuous to suggest that just because the court didn't devote one of that 54-page opinion that he wrote on all this to somehow going back and seeing if all these unrelated conglomerate of issues that he made individual rulings on could come together in a congregate sense and have some super Eighth Amendment issue with it.
I had some, it is sort of inherently contradictory to challenge the alleged isolation of prisoners for too long a time on the one hand, and the likelihood they're going to get assaulted by other prisoners on the other hand. So what was the synergy between those two claims?
Well, I don't know, but I do know that, of course, this was a mental health hospital. There are people in that are in segregation cells that are kept that way because they're a danger to the staff of the prison. They're a danger to the other inmates in that prison. That's part of it. It's also got a disciplinary aspect of it too. And there's some institutional safety concerns that have to be looked at with respect to this and to give some judgment and discretion to the people, the professionals managing that prison as to how they're going to discipline and deal with people that are real.
I take it in that section, do you use indirect supervision in that section or those units?
I'm not certain I understood that question.
Well, it's talking about this pod formation and indirect supervision from above. Does that apply in the units where the prisoners are single-celled?
The physical layout, the architecture of all of the housing units are the same for the most
Okay.
part. And there's minor differences, but they're all the same. Of course, there's one housing unit that's used for the isolation inmates, which was housing unit 5. And, you know, they never come out of their cells unless there's some way they defeat a lock or something and come out. So they don't, that's probably not something that they have to watch quite as closely as they do all the other housing units where they have people out in the day rooms all day. But it's not just one person walking around in a turret type situation watching 4 different pods in a zone. There are people on the first floor that are walking around the bottom level too. So they're looking at, plus everything about this facility is video. They have video monitors everywhere. This is a modern facility for what it's worth to just
Right.
It's air conditioned, it's heated. You know, the day rooms all have big screen TVs in them. The inmates all have headphones. Even in the segregation units, they can still watch television with headphones. So this is a far cry from some dungeon type prison that was built back in the late 1800s or something. This is a good facility. And one of the most important things we contend that the district court did here, in addition to being very engaged in the testimony that went on over a long period of time, was he went into that facility. He drove over there by himself, spent a half a day, walked with the warden all day, saw the programs.
That was in the post-trial period, right?
No, ma'am, it was during the trial
Pre-trial.
itself. It actually was between the close of the plaintiff's case in chief and the beginning of the defendant's case in chief.
But then he did see photos in the post-trial.
The photos I think he was referring to in his opinion were photos that were taken back in the 2012, 2013 time.
Right.
That were, they were not flattering. I mean, they were snapshots. And I think another thing I would like to at least speak on just for a second is the court made no findings about whether the conditions in that prison were unconstitutional back when at the time the suit was filed and before. He was very careful to say, I'm not making that finding. I'm just saying the conditions were much different, and they were much different. And for one thing, fires were a big issue back then, and anytime you set a fire on a door slot right outside of a cell and, you know, it smokes up everything, it looks terrible when you go take a photograph of it. Now, it's painted 2 days later, and it looks fine, but so he knew what he was looking at with that evidence.
All right, sir, you had 10 minutes.
Okay. Thank you.
All right, thank you. Mr. Bentley?
Good afternoon, Your Honors, and may it please the Court. Michael Bentley on behalf of Commissioner Burl Cain and the other defendants and appellees in this case. My responsibility this afternoon is to discuss the plaintiff's Error 3, which is a challenge to the district judge's evaluation of their expert testimony. And I want to do that and then also try to touch on some of the things that have been discussed so far today.
Before you get into the experts, what is with all these changes that the district court relied on, some of them, obviously, there's new contractors. Some of the things like changes in the policies for prescription medication, are those in documented policies? Are those just practices? How I think it goes to the issue of maybe how the risk of going back to the old ways is, how great that is.
Yes, Judge Costa, I think I would start by saying yes, the changes that Judge Barber addressed are documented in policies. There was testimony about updates to policies at the trial. There was additional information about updates in the post-trial discovery period that came in through reports. And then a lot of the changes, as he documents on a factual basis, are changes in practices brought by a new warden, brought by a new healthcare provider, brought by a new commissioner of corrections. So I think if you read his opinion, and I would say the plaintiff's experts in this case do not really challenge the policies at East Mississippi. This is a pattern and practice approach to this case. And what they argued and what Judge Barber addressed was that if you look at the facts, the policies are not being adhered to. And his opinion very thoroughly dispels that concept.
So, for example, one of the things with medication, I think now if you miss 3 days of medication in a row, they have steps to take to make sure it doesn't happen again. Is that a policy, or is that just what they're doing now from the evidence?
That would be, that testimony came in through nurse practitioner Evelyn Dunn, and that would be, I think, a practice at that time that was later, as Dr. Bonner, the chief psychiatrist, talked about in his post-trial declaration, things like that became part of policy. I do believe if you look at the time of trial, nurse practitioner Dunn was talking about changes that were implemented by the predecessor psychiatrist and followed through by her that did not necessarily involve rewriting policies, but living up to the policies that existed at that facility at the time. So turning to the expert issue, if I may, Judge, in a case like this, the district judge is obligated to admit and hear qualified expert testimony and then give that testimony whatever weight he or she determines it deserves in the context of all of the evidence that came in at the trial. And there was a lot of evidence at trial, and to Judge Jones's point at the outset, I would like to give a couple of record cites because I think this will give the court context of the type of evidence that Judge Barber was looking at. I think the best place to go to understand that is the plaintiffs' and the defendants' post-trial briefs, which are in the record. The plaintiffs is at document 843, and the defendants is at document 846. And then also look at the closing arguments, which are trial transcript 38, April 9th, because that is going to give you a good synopsis of the significant amount of evidence that Judge Barber was confronted with and asked to distill. And in a case like this, Judge Barber got the law just right. When an expert or multiple experts testify in a conditions of confinement case, their testimony may be helpful or relevant to determining professional standards or best practices, but they are not controlling in setting constitutional standards. They don't establish constitutional minimums. That comes directly from Rhodes versus Chapman, the Supreme Court's case from 1981, and from this court's decision in Green versus Farrell from 1986. So what Judge Barber did was hear the expert testimony. The plaintiffs in Error 3 complained that 4 of their experts were ignored or disregarded. And that's simply not correct. If you look at the course of proceedings, Judge Barber admitted all 4 of these experts, heard 7 days of testimony from these 4 experts out of a total of 21 days of trial, did not exclude any of their testimony, did not exclude the experts. Then after trial, requested additional, allowed them to go back to the facility and requested additional testimony in the form of expert reports. He considered all of this. He did not give it controlling weight because the law says he should not. But he certainly considered all of it, and if you read his opinion, his final opinion in order, he walks through in each of the claims that plaintiffs are challenging here, medical isolation and protection from harm. He acknowledges the expert testimony. He acknowledges their expertise. And he walks through all of the countervailing evidence, or a lot of it, not all of it, because that would be impossible in an opinion that's able to digest. But he walks through all of the countervailing evidence and explains why he, as the fact finder, certainly listened to and credited the plaintiff's experts, given the way that he felt they were deserved, but did not treat them as establishing constitutional minimums or controlling his decision about what the Eighth Amendment's Cruel and Unusual Punishments Clause requires. I do want to talk just briefly about the Fourth Circuit's decision in Porter to pick up on the discussion earlier, because I think there's some significant differences between Porter and this case. And the first I would say is that in Porter, you had a case that it was undisputed that there were violations of the Eighth Amendment at some point in that facility. That case dealt with solitary confinement or isolation. You also had the state, as the opinion points out, waiving on appeal that there was any penological reason for the conditions at that facility. So you have undisputed Eighth Amendment violations, waiver on appeal by the state, and an argument that even though there were violations and they waived any penological justification, the state argued that they had mooted the constitutional violations. That is a far cry from this case, where you never have a finding. You certainly have references that perhaps there were violations in 2012 or 2013. But you never have a
You
finding.
point to something that confused me. I mean, this is not a mootness case, is it? This is, did the district court abuse his discretion in deciding not to enter injunctive relief case? I don't know if that makes a big legal difference between this case and Porter, but it did strike me that Porter was talking about voluntary cessation, which just seems apples and oranges here, but.
I agree, Your Honor. It makes a big difference in the burdens, for one thing, because in a voluntary cessation case, the defendant has to prove that they're never going to revert to the conditions that existed before. In this case, a traditional Eighth Amendment case, Farmer versus Brennan controls, and the plaintiff maintains the burden throughout, demonstrate that at the time, leading up to and at the time of trial, there is an existing violation at this facility. So I think it's a very significant difference when a defendant comes in and argues mootness, as opposed to this case where the defendant defends the claims and ultimately prevails on the facts in the case, and the district judge says there was never a violation, at least when I decided the case, and there's no basis for an injunction. I also want to touch just briefly on Wilson versus Siler and this concept of totality of the circumstances. This case was tried as a class action. The plaintiffs presented throughout this trial 7 different claims covering all facets of prison administration. And under each of those claims, there were multiple subclaims and theories and evidence. And Judge Barber walked through each of those claims in his opinion, found that under each of those 7 broad categories, there was no objective violation of the Eighth Amendment. Certainly in a facility like this and in a system like this, you'll find isolated incidences of individual inmates, their rights perhaps being violated. But he said, when you're proceeding as a class, a prison-wide class, I find no evidence of a serious risk of harm to all 1,100 or 1,200 inmates in this facility. And then he said, even if I were to assume that there's such evidence, I find no evidence under any of these categories that the Commissioner of Corrections, the warden, the chief psychiatrist are ignoring the type of concerns that are being brought. I don't know of any authority, and the plaintiffs have not pointed to any, where if you cannot prevail on any of your claims, you haven't established any constitutional violations, under any of 7 broad categories, you can somehow aggregate all of these failed claims to come up with a single totality of the circumstances claim. I don't think Supreme Court precedent or this court's precedent would support that.
They didn't have a single plaintiff today who was a victim of all 3 deficiencies.
No, Your Honor, they did not. They did not have a single class rep that satisfied all of those. Thank you, Your Honors.
All right, sir, thank you. Mr. Salk, rebuttal.
Thank you, Your Honors. May it please the court.
Why did this litigation extend over 6 years or more?
Well, Your Honor, several reasons. There were, discovery was very complicated, required several extensions. There was a delay while we were waiting class certification. The case was tried in 2018, and then there was a period of post-trial discovery. So it really just procedural issues. Your Honor, I'd like to address something Mr. Siler mentioned, which is that the characterization of this as a shotgun approach case. I think that fundamentally gets to the heart of the issue here and the mistake that the district court made too. This is not a shotgun approach. What plaintiffs did in this case was to present evidence that should be taken together to show why deprivations expose them to a substantial risk of serious harm. And the court treated it like a shotgun case by separating out each practice and asking whether it violated.
Well, I mean, take Judge Costa's example, which I thought was a good one, of a challenge on the protection of inmates claim, a challenge to the indirect supervision, followed up by but even if indirect supervision is okay in principle, in practice you haven't adequately staffed. Now, as I read Judge Barber's opinion, he actually is doing this sort of synergistic approach where he's saying, well, look, let's consider whether the implementation of the indirect staffing here was so, inadequate. But he makes findings that it wasn't. So why isn't that an example of him doing what you said he didn't do?
Well, Judge Duncan, precisely because we never claimed that indirect supervision is unconstitutional. The case being made here was that it was a contributor to a set of circumstances that expose people at this prison, as it is applied and practiced in this prison, to a substantial risk of serious.
Was, in other words, a contributor to the inadequate staffing of the positions?
No, Your Honor. Inadequate staffing itself is a contributor to the risk of harm that people experience. But the relevant question is whether that circumstance, in conjunction with others the district court never addressed, exposes people to a substantial risk of serious harm. So, for example, and Judge Jones, to your question about the intersection of isolation and protection from harm, the fact of the matter is, people even in solitary confinement were being assaulted. At ROA 28901, Gary Long testified about how in the weeks before trial he had been assaulted twice in solitary confinement.
How does that happen? What does it mean by that?
Excuse me?
What exactly does he mean by that? I saw that in the brief.
He means that he was being escorted by officers, and because of problems with doors being secured, which was another issue the district court never touched on, doors cannot lock properly in this prison, or at least typically do not lock properly. So even in solitary confinement while being escorted by staff, other inmates are able to escape their cells and assault this person, and it happened twice in the weeks before trial. You wouldn't know that reading the opinion, and we don't, it's not our position that the court must decide every single fact like that, but it must.
Normally, if we have a question, Farmer was a prisoner assault case, wasn't it? And what we used to get was a case where prisoner plaintiff says, I'm a member of such and such a gang, the members of this other gang are at war with us, they're out to get us, and the prison officials ignore that possibility. You don't have anything like that here, do you? You don't have a systemic showing. I didn't see it in your brief anyway.
We have a showing, Your Honor,
General
that...
allegations.
Excuse me?
It looked like your brief was very vague about that.
Your Honor, there's evidence at trial that gangs, in fact, control everyday life at the facility as a result of staffing inadequacies, among other things. But the contention, again, is not that gang control is itself unconstitutional. The problem is it contributes to a circumstance where people are exposed to a substantial risk of serious harm. Unless there are any further questions, Your Honor, I believe my time is up, so...
Very fact intensive. We'll take it seriously. Thank you, sir.
Thank you very much.